Good morning, good afternoon, good evening. It's just gone 2 p.m. here in the UK. I'm kind of getting up later and later and later and going to bed later and later and later. It's like I've turned nocturnal or something. Anyhow, this is a topic that I find very interesting. This is Bryan Kohberger's latest hearing, pre-trial hearing, which happened a couple of days ago. Bryan Kohberger, of course, you will know, is the accused killer of Ethan, Maddie, Kaylee, and Xana from Idaho, Moscow, Idaho, November 13th, 2022. Four University of Idaho college students were brutally murdered in their beds. And just over a month later, 6 weeks after the crimes, Bryan Kohberger was arrested. And very controversial is the Bryan Kohberger case, because lots of people think he's innocent. Right, of course, he is innocent constitutionally. He's innocent until proven guilty in a court of law, being judged by a jury of his peers. But factually, lots of people believe he's factually innocent. Now, I've not been shy of saying that I believe they've got the right man. I do believe they've got the right man. However, that's not what we're talking about today. We're talking about whether Bryan Kohberger can get a fair trial. And that was the topic of the hearing, which went longer than 7 hours. So it was all day of a job, and very interesting. The defense want the trial to be moved from Latah County and moved to Ada County, which those of you who followed Daybell, you'll know that Daybell had his trial in Ada County. It's a much bigger county, and the court would be in Boise. The problem is, this is like 300 miles away from Moscow, Idaho. So it's a big undertaking to move this trial to Ada County. Now, the state don't want the trial moved. And I was a little bit disappointed with the state because, yes, they cross-examined the defense's witnesses, 4 of them. I'm going to play some clips from them. I was a little bit disappointed in the state. So although they cross-examined those 4 witnesses, they didn't put any new witnesses of their own. They just gave like a summary of the reasons why they didn't want the trial moved. And I'm going to tell you, I've got no horse in this race at all. I wouldn't be upset if they moved the trial, nor would I be upset if they kept the trial in Latah County. So I'm coming at this topic from a truly neutral standpoint. So although I believe they've got the right man, where the trial actually takes place, I've no horse in the race. I'm neutral, completely neutral. So I've been able to watch this hearing, listen to the witnesses, very interesting witnesses, with a completely, truly open mind, because I don't actually care where they hold the trial. But and what I want to do in this live stream is give you the benefit of my experience, my qualifications, my experience, my training and experience, as they say in trials. Because for over 20 years, I worked in psychology. I was a psychologist. I've not worked in psychology since 2021. So I'm actually 3 years behind this topic. Because actually, interestingly, jury decision making was one of my areas of expertise. It was what I taught for many years and what I did researching for many years. One of the things that I did researching for many years. But when I quit my last job in 2021, I haven't looked at the academic literature in psychology at all. I haven't kept up with it at all. So this morning was the very first time that I've done a search for new papers, new pieces of writing new journal articles on jury decision making since 2021. And there's been a whole bunch of stuff that has come out since 2021. So I've only had a cursory glance at it and particularly focused on the topics that were brought up by the defence's witnesses. All right. So I know that a lot of law tubers, like lawyers who do YouTube, have covered this, have played clips on and given the benefit of their experience from a legal standpoint. Hopefully, I'm able to offer something a little bit different in offering a psychological standpoint. And again, I'm completely objective, but I do want to point out that the psychology in this area is very problematic. And that's coming from someone who did research in this area for many years. So there's that. So we're going to play some clips. Going to go through the hearing, just playing some very, very short, very selective clips. And then I want to play at the end the state's response, because the vast majority of this hearing was dominated by the defense, because it's their motion. It's them that desires the trial to be moved, fearing that if Bryan Kohberger's trial stays in Latah County, that he's not going to be able to get a fair trial. So above all, above anything, whether you believe that Kohberger is factually guilty or factually innocent, surely you should all want him to have a fair trial, because if there's any sniff, like his defense are very good, right? They're on it. I don't agree with much of what they say, but in this instance, for this particular topic, I am completely open-minded, completely neutral. So I can't be accused of bias in any way, because I don't have a horse in the race. I honestly don't have a horse in the race. But as we go through, I'm going to point out some things, just, based on my training and experience, as to what's problematic, what's right and what's not so right about the things that these witnesses said. And again, I am disappointed that the state didn't put on any of their own witnesses to basically counter some of these things that were said by the defense witnesses. I don't think the state, this is just my opinion, but the state didn't come across as being terribly prepared, honestly. Like the defense, like an impressive array of witnesses, and the state just said a closing statement. Yes, they cross-examined. Yes, they did bring up some very important points during that cross-examination, but I am disappointed that they didn't want to counter it with any of their own witnesses. So let's see who's in the house before we continue. So this is Sunday afternoon for me, Sunday morning for most of you. So I'm guessing people do things on Sundays, maybe church, maybe shopping, maybe visiting people. So I'm not expecting this live stream to be terribly busy, but it is what it is. And people can always watch on the replay. Hello, Linda. I hope it will be interesting. Like I said, it's looking at this topic from a little bit of a different perspective than what all the law tubers have. Hello, Naomi Rose. Hello, Danny. From Oz. So it's time. Oh, it must be late at night for you guys down under. Hello, Jackie. Hello, Kelly. CW's been in Aldi. Aldi. For those not in the UK, Aldi is a supermarket. They're like a discount store, so you can get like loads of things cheap. Everything's cheap in Aldi. You can get some interesting things like the middle aisles. Like, it's just random. And I miss Aldi. My last place of work, where I worked for 7 years, they had an Aldi right across the street. So if I was bored of a lunchtime, I'd go for a mooch round Aldi and come out with some bizarre purchases. So yeah, I miss Aldi because there isn't one like dead close to me. There's one in the town, but you know it's a bit of a faff to get there. I wish we had an Aldi. We have a Co-op, which is mega expensive. We don't have an Aldi. Hello, Holly. Trio Girl Mom. Cami, hello. Lisa from Central Florida. Karen, happy Labor Day from North Carolina. We don't have Labor Day here in the UK, so I don't know what Labor Day actually stands for. We have bank holidays, though. We had a bank holiday last week, so I don't know whether it's similar to that. But happy Labor Day to everybody. Rightfield, hello. M. Osland. Broken Goth Don. Yeah, Vincent Starry Night. Well, yeah, I put that backdrop on my thumbnail because we know that Kohberger likes to go driving at night to see the moon and the stars. So I thought that was an appropriate thumbnail. Two Arctic Wolves, hello. Hello, hello. Paper Chaser, Shelley Roo. Heather Feather. Sirius Black. Shaker Maker. Oh, sorry, Shaker Sister. There is a Shaker Maker who hops in, so that's different. Shaker Sister. Unless you change your name, you might have changed your name. Kimberly, Pincho. That was a quick day. What, 7 hours? Down Under with Love. Hello, Steph. Oh, Purple AJ. Purple AJ, Walkabout Bridge, Mary Jane, Jackie. Purple AJ has gifted 10 memberships. Now, I missed that. Let's go back and see who has got these 10 memberships. Thank you so much, Purple AJ. Once again, an absolute superstar. Hold on, let me go back in this chat here. I wish StreamYard would let me see who got gifted memberships, but they don't. So I have to go to YouTube. All right, we've got Walkabout Bridge, Mimi, Tonya, BCTV, a different videographer with opinions, David Gray, Magnificently Flawed, Dark Times, Ruby, Dream Suburb, and can I go back any further? Yeah, I can. Emily and Pretty Little Lights, welcome you 10. You get a monthly membership courtesy of the truly wonderful Purple AJ. Hello, Mike, Terry Ann. All right, I'm going to stop now. And get into this this live here. Okay, let's make this bigger so that we can see it. All right, so I'm going to start at the 1 hour 5 mark. And this is the first witness. He's partway through his testimony. This is someone called Todd Murphy. Never heard of him before. But he has a company called TrueScope. And they're like a media analysis company. So they basically analyze stuff in the media. All right. So he's got these pretty pie charts. I do love a good pie chart. I'm not really sure he needed pie charts because it's just two colours. I don't know. I like my pie charts to be a little bit more complex. But anyway, it gets the point across. So I'm going to play a few minutes of this. And you love a good pie. Yeah, we all love a good pie. Love a good pie. Yeah, I like apple pie. Apple pie is great. Apple pie is my favourite pie. Black currant pies are good as well. Apple and black currant's good. Anyway, let's start. So this is Todd Murphy. He's being questioned by the defense here. And the audio isn't fantastic because Judge John Judge, he stopped the cameras coming in, like the pool cameras, like, Court TV and those cameras. He stopped those because they were focusing in too much on Bryan Kohberger. So it's weird that both the state and the defense wanted cameras out of the courtroom. They wanted cameras gone, both sides. But Judge John Judge, fantastic judge, I really like him, said, no, we want this justice to be heard by as many people as possible. However, he did concede that the Court TV or whatever pool camera it was honing in on Bryan Kohberger, like coming in, sitting down. Lots of comments were being made about his sharp suits and stuff like that. So the compromise that he came to was that he was going to have his own YouTube channel. Judge John Judge has got his own YouTube channel, and they stream the hearings, and presumably the trial's going to be this way as well. He streams from his YouTube channel, but everybody else is allowed to restream. Like while it's live, they're allowed to restream. So like Court TV, Law and Crime Network, etc., and any YouTuber who's streaming is allowed to stream directly from Judge John Judge's YouTube channel. So the audio isn't fantastic. All right. So I've got the CCs on, so that will help. And I'm playing this from WFLA because I found I tried a few, and WFLA does seem to have slightly sharper audio than Law and Crime or Court TV had. So WFLA are very good at their streaming. Like they have a dedicated stream center, so they're able to, I think, just upgrade the audio just a tad, just a little bit. But the audio isn't fantastic, I do have to say. I've got it sped up to 1.25 just to get through this a little bit quicker. But if it's too quick, it's not. I don't think it's too quick. But if anybody really struggles, then I can put it back to normal speed. It just means that we get through it just a little bit faster. All right, so we're starting at the 105, actually 103. My timestamp's 105, but I'm going to just skip it back a couple of minutes so that we get the context. So what Todd Murphy is presenting is the volume of media. So he's comparing the volume of media, the amount of media in Latah County regarding Bryan Kohberger, so specifically relating to this case, compared with other areas of Idaho, and also looking at the population of each county. So kind of comparing the media interest, the media volume in Latah County, and then kind of putting that in terms of the population. So the defense want the trial to go 300 miles away to Ada County because it's a much bigger county, so they've got a much bigger jury pool. The counties in between Latah County and Ada County are kind of small counties. They might not be small in area, but they're smaller in population. So their idea is that, you know, a county with a larger population size, they're going to be able to get a bigger jury pool and people who can be truly impartial. However, when we get to the psychology bit of this, I'm going to point out some issues. But I just want to play this at the beginning just to give you a feel for where the defense is going and why the defense want it moving. All right, so let's start here.
At this page here, can you please explain to the court what this is?
Sure. You have two pie charts. On the left, you have the volume of media coverage specific to the keywords and phrases searched for our client related to this case. You see on the left, out of all the media coverage between January 2020.
It's too quick. You think it's too quick? Oh, I'll put it to normal speed so that we're all right. It sounds really slow to me because I listen to everything on either 1.5 or 1.75, depending on how quick the people are talking. But I appreciate that. If you're not used to it, then it sounds... Harry Potter's Sphere says, no, it's not. I think if you're used to listening to things in quick time, normal speed is too slow. But we'll play it on normal speed. We might as well, because the clips aren't massively long, and yeah, it'll be fine.
23 and July 15th, 36% of that coverage, or just over 36% of that, was seen or had the opportunity to be seen in Latah County. On the right side, you have another pie chart that shows the population of Idaho, and it shows what percentage Latah County represents of the total percentage of Idaho, which is 2.75%.
On the second bullet point of notes there's some reference to census. Can you explain?
All right. So the issue I've got here with Todd Murphy's entire presentation was that, yes, there is more media in Latah County. So they used a series of keywords, things like Idaho 4, Moscow murders, all the hashtags that people use when they're referring to this case, and Bryan Kohberger, Idaho murder, whatever. There's a whole bunch of keywords that they could use. And they found that 36% of the media between the particular date ranges, so what have we got here, 1/1/23 and 21 or 31/5/24. Let me just look at it on the bigger screen. Can't see that. All right, okay, so 7/15. So between the 1st of January 2023 and 7/15, so that'll be the 15th of July 2024. So that's the date ranges. So between those times, 36% of the media that they investigated in Latah County was relating to this case. So that is huge. It's like over a third of the media volume in Latah County, like in the media specific to Latah County, was relating to the Kohberger case. So I can understand why the defense are perturbed by this, given that Latah County is actually only 2% of the overall, or 2.75% of the overall population of Idaho. So there's a hugely disproportionate amount of media about this case in Latah County compared with other counties in Idaho, even though Latah County is only a very small proportion of the population. However, my issue with this entire presentation is that this is just the opportunity to view it. It doesn't give us any indication at all about who is actually paying attention to this media. Because you could have 36% of all the media volume in publications specific to Latah County, but yet next to nobody's listening to it anymore. Like, people might have listened to it early on in the case, like this is the 1st of January 2023, when Bryan Kohberger had just been arrested. Yeah, you're going to have lots of people in Latah County who express an interest. But now, like 18 months down the line, maybe people have tuned out. Maybe there's been too much media in Latah County and people have actually just tuned it out. We don't know. And Todd Murphy's presentation suffers for that reason. His entire presentation suffers for that reason. So although at face value, this looks scary for Bryan Kohberger, that, there's just this disproportionate, relative to the population, there's this disproportionate interest by the media in Latah County. That's scary. That would be scary for any defendant. But it tells us nothing about how attentive people are to this media. And that's the problem.
That note.
Sure. The census data used for this one's from, I believe, July of 23. Of the 40,924 people in Latah County, we were asked to look at age eligible to serve on jury duty amongst all of that the people in the county, which equated to 61%, or just under 25,000 people of the nearly 41,000 all are age eligible to serve on the jury.
Right.
In Lake Talk.
Going to the next page.
Okay, so there's 25,000 eligible jurors in Latah County. So they're going to have to pick, if this trial stays in Latah County, they're going to have to pick 12 members of a jury, and then however many alternates they have. I don't know how many alternates they'll choose. I'm guessing that they'll have a fair number of alternates because this trial is estimated to going to last for 3 months. So, you know, jurors getting sick, jurors being compromised in some way. You know, what they don't want to do is just have a few, like, let's say 4 alternates, and then they run out of jurors. In 3 months, anything could happen. So I'm guessing that Judge John Judge is going to want to have a fair number of alternates. So let's say, just as a, you know, a number, let's just say they want to pick 20 potential jurors out of 25,000 potential eligible jurors in Latah County. So just bear that in mind, that they need 12, but let's say they choose 20, so they've got plenty of alternates out of 25,000. So surely they would be able to get 20. This is from the state's opinion. From the state's opinion, they're saying, and we'll listen to what the state says at the end. Surely we're able to get, you know, 20 or 12, 20, however many impartial jurors from a population of 25,000. It doesn't seem that it's going to be too much of a stretch to be able to do that. Okay. That's what the defense is trying to counter. They're trying to say we have no hope of getting an impartial jury in Latah County. Okay. Next slide. This is Ada County. So I just want to play you Ada County. So this is a much bigger county. You can see that the population here of Ada County is over a quarter of the population of Idaho. And I'll let him explain.
What does this page tell the court?
This is the same analysis framework performed on a different county. Again, on the left, you see the total media coverage in Idaho for the same date range, but 34% of the media coverage was seen in Ada County, which is just a couple percentage points below that of Latah County. The primary difference is the right-hand pie chart, which shows the population of Ada County relative to all of Idaho, and it's over a quarter of the state population, in Ada, or 26.42%.
What conclusions do you draw when you compare the two counties' data?
There's a lot more people in Ada County, and where I would be going with that as a media analysis, when I would interpret this from a media analysis perspective, is the propensity to dilute the media exposure in a larger population is a factual function of that. If you have a certain number of stories divided by the population, the number of stories a person can see is fewer if the population is larger. Did that answer your question? Or it was like, yeah.
I'll follow up with another specific one. Out of the two counties, where is the most opportunity for a resident to view stories about this case?
It's by far in Ada County. When we did the analysis of the age eligible process, nearly 300,000 people in Ada County are jury age eligible, compared to just under 25,000 in Latah County. I'm gonna just ask my question again. It was probably inartful on my part.
do more people in Latah County, is there more saturation in Latah County or more saturation with media coverage in Ada County?
Yes. A person in Latah County would be exposed to far more media coverage than people, a community in Ada County.
Can we now switch?
No, I don't agree with that. I don't agree with that. And here's why. In Latah County, the pie chart on the left, which is the volume of media about the case relative to other media in the case, was 36%. In the same date range between the 1st of February, the 1st of January 2023 and the 15th of July 2024, almost the same amount of media was presented, the media volume in Ada County, 34%. Now, I would guess that 36% in Latah County versus 34% in Ada County would not be statistically significantly different. Like the numbers 36% and 34% are not sufficiently different enough to convince me that people in Ada County have less opportunity to see media about this case than in Latah County. Bear in mind, Ada County is like 300 miles away. And it's only 2% less. Like the media volume is still huge compared to all of the media. Is still huge in Ada County. Across like nearly, 18 and a half months. So even though there's more potential jurors in Ada County, 300,000 potential jurors, because it's population dense, it's over a quarter of the entire population of Idaho. So there's 300,000 eligible jurors, whereas there's only 25,000 eligible jurors in Latah County. Now, you might be able to get a more diverse population from Ada County, but not necessarily. What I'd like to see is the demographics of Ada County compared to Latah County. I'd like to see a full breakdown of diversity. Demographics is like your personal, like details like age, gender, nationality, ethnic origin, socioeconomics, like how much do you earn, those kind of things. I'd like to see a breakdown of that, because arguably, if Ada County is more diverse, then arguably the 20 people or 12 or 20, however many that you choose for your jury, you might arguably get a more diverse sample in Ada County than in Latah County. However, they're not necessarily choosing jurors based on diversity. It's not like they're going to choose, like, let's say 6 women and 6 men, and they're going to choose, 4 that are going to be, white Americans, and then 4 is going to be black Americans, and then 4 is going to be Native Americans, and then 4 is going to be whatever, right? And they don't choose jurors on that basis, do they? They choose jurors based on their ability to be impartial. So my point here is, what difference does 2% make? Seriously, what difference does 2% make on the media volume? Like, still over a third of the media. I mean, I find this crazy. A third of the media in both Ada and Latah counties is about Kohberger, compared to all the other media in that specific media that focuses on those counties. So to me, it doesn't matter about population size, because in Latah County, you've still got 25,000 eligible jurors. Surely you can choose 12 impartial people and then however many alternates out of a potential juror pool of 25,000. Just the same as you could get 12 and then however many alternates from eligible jurors in Ada County. So to me, this isn't convincing data that convinces me enough to say, based on this information, it will be safer to move the trial to Ada County. Based on this information alone, it's not convincing enough to me. And the same fundamental flaw that I just mentioned in relation to Latah County is also evident for Ada County. That is, this is opportunity. It doesn't tell us anything about what was actually viewed. It doesn't tell us anything about the amount of interest that people have in Kohberger's case. Just because the media continually run stories about it doesn't mean to say people are actually really attending to it anymore. And again, like I said, for Latah County, just after Kohberger's arrest, so he was arrested on December 30th, 2022. So immediately after the arrest, yes, everybody's focusing in on Kohberger. Everybody wants to know who this guy is. Everybody's digging in, right? Even people who only, I don't know, take a cursory glance at true crime probably saw something about Kohberger in January 2023. But are they still attending to that media? We don't know. Based on these figures alone, we don't know. Okay, so what could be more convincing then than these pie charts? What could be more convincing than a media analysis person telling us that there's a lot of media about Bryan Kohberger out there? Well, what about psychology? So the next witness from the defense here, we're going to skip to that now, is, where's JB? They had a break, so JB's hopping in. So this is the next witness coming on now. So I'm going to let her state her name and her occupation, and then I'm going to skip to my timestamp that I want. All right. So she is a psychologist.
Back on the record, State versus Kohberger, CR 2922-2805. Sorry for the delay. I think we had to adjust some mics, make sure everybody can hear. And counsel and Mr. Kohberger are here in the courtroom, so we're ready to go forward. Next.
Hold on, we've got persons. Hello. I'm doing a live stream. Okay. Claire's just coming from work, so there might be a little bit of disruption in the background. There might not be.
Witness.
Thank you, Your Honor. We will call Dr. Anani L. Alili.
All right, thank you. Thank you, ma'am. Please raise your right hand.
You solemnly swear or affirm that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you. Please have a seat and then please state your name and spell your name.
Her name's Amani Elalili. Last name is EL-ALAYLI.
Thank you. Ms. Taylor.
Thank you. Good morning. I can see you brought some papers to the witness stand with you today. Will you identify what those are?
Yeah, it's just copies of the slides. It's nothing. None of my kids I couldn't see.
Okay, and if the slides, does that refer to the PowerPoint presentation that you for us to share today?
It
Okay. At this time, will you place that document in front of you face down? And if you have difficulty seeing the slides, let me know and we'll have you turn it over so you can track and help us understand what you're going to teach us today, okay?
Sure.
Yeah, I want to make sure then the state has stipulated to admit that.
That's
Those
correct.
slides. Okay, thank you. So all the slides that we might be considering today, you agree to.
That's correct.
Okay, thank you. Go ahead.
Thank you, Judge. Will you tell us what you do for work?
I'm a professor at Eastern Washington University.
What do you teach?
I teach social psychology, which is the study of how people interact with each other and influence each other, how we're all affected by social situations.
All right, so she's a social psychologist. Oh, we've got 5 new members here. Let's hop in to my YouTube chat here and grab these. Oh, come on. I need a mouse. So I need a mouse. All right. Okay, Kimberly, thank you so much for gifting 5 memberships. That's very kind of you. We've got Cami, Terry-Ann, Tam here, Sassy, and Spencer, SC Spencer, I think that says. Welcome. Welcome, you 5. You get a month's free membership, courtesy of Kimberly. Thank you so much. It's very kind of you. All right. Okay. Okay, we're good to go. So she's a social psychologist. Social psychology is the study of how individuals interact, their behaviors, their thoughts, how social situations, groups, and etc., all influence the individual. All right, so that's what social psychology is. So this is what she studies. This is what she teaches. I also taught social psychology. Social psychology was one of my areas of expertise. Social psychology is a huge topic or a huge area, and lots of different fields of study within that. All right, but a lot of what social psychologists do is survey studies. So, questionnaires, getting people's opinions on things. And this is what this witness is going to talk to us about. And I did feel like I was in back in my undergraduate days. And she did very much launch into like lecture mode. It was very much a mini lecture that she gave us. So yeah, social psychology was one of my areas of expertise, along with forensic psychology. So, all right. So I want to skip to my timestamp now. Just wanted to introduce herself. So 1:59 I want to go to. So let's skip a few minutes here. All right. So she's talking to us about the research on exposure to pretrial publicity. All right. So is exposure to pretrial publicity negative? Does it negatively influence potential jurors? That's the question. All right.
illness or the medication has a serious risk. But I would be much more confident if there were a whole bunch of studies, dozens of studies combined, and thousands of participants' data. And so a meta-analysis basically does that. It narrows down a specific topic, in this case, the effects of pretrial publicity on judgments, and it examines overall, combined, is there an effect? And so there were, like I said, one is quite recent from 2022. So it's the simplest way to describe this research. It's the easiest way for somebody to know where it stands, even if they don't read all the articles. And what this work has found is that if somebody's...
All right, so a meta-analysis. She's talking about a meta-analysis that took place in 2022. So what is a meta-analysis? She didn't explain it terribly well. So in an area where a lot of research has been done and pre-trial publicity, jurors' biases based on pre-trial publicity, all of that stuff has been a very popular area of research over the years. So lots of individual studies have been done, right? Looking at different variables, looking at different samples, looking at different types of pretrial publicity. So positive, because pretrial publicity can be very negative, but also it could be positive. You know, if a defendant is very well liked in their community, if a defendant, you know, the publicity towards that defendant is generally positive, then that might have a different effect on the biases of potential jurors than negative pretrial publicity. Obviously, that's just common sense. All right. So there might be tons of studies. A meta-analysis is a type of statistical analysis whereby the results from lots of different similar comparable studies are combined into one big study. All right, so they take the results of, let's say, 30 different studies. Now, they have to be measuring the same thing. They have to be comparable. You can't compare apples and oranges in a meta-analysis. So I also used to teach statistics. So this is giving me flashbacks to me being in a computer room teaching meta-analysis to students. Oh, dear God. Dear God, forgive me. Forgive me for all my sins. All right. And I say that for a reason. I say that for a reason because much of this research is absolute pants. It's nonsense. Most of... Oh, dear. There's so much psychological research that's published that's absolutely rubbish, that is not worth the paper it's printed on. Seriously. Seriously. Forgive me for my sins because I contributed to it. Not that my studies were rubbish. My studies were great, but I contributed to the bulk of stuff out there that is potentially misleading. And yeah, so it's actually the real reason why I'm doing this live stream. To tell you that the majority of psychological research is nonsense. And I say that as a psychologist. I say that as a psychologist, but it's why I don't watch psychology YouTubers. It gives me flashbacks. All right. Back to earth. So yeah, a meta-analysis compares in one study, in one set of statistics, the overall results of, let's say, 30 studies or however many studies that they're able to fit into one study. All right, so that's meta-analysis. And indeed, it's the case. Indeed, it's the case that there are many studies on the effects of pretrial publicity. But I'll refer you back to what I said a few minutes ago. I'll refer you back to the media volume. I'll refer you back to me saying it doesn't matter how much media is out there on a particular subject if people aren't attending to it. Meme, thank you. Welcome to Secret Agents. Thank you for joining.
He's exposed to publicity about a case, something about the defendant, something about the case, fact, fiction, that the tendency is, if you look at everything as a whole, for it to affect judgments, and specifically how much you like the defendant, your inclination to think that they're guilty, your judgments of their criminality, etc. And this has been shown with individual judgments of guilt, but even more so with group judgments, with juries. And it looks at participants who are randomly assigned to get pretrial publicity information or not, so that you can really determine cause effect. So this would be a formal experiment. We do lots of studies, and experiments are the ones that I like to look at, because what you do is you hold everything constant except for one thing that you change. You get one experience, another group of people, another experience, and then expose them to all the same things. So all the same trial stimulus materials. And you see, okay, the people who got some information ahead of time that they weren't supposed to pay attention to, did they evaluate the evidence differently? Did they come up with different judgments? And so the meta-analysis in 2022 is based on over 11,000 total participants, and it summed up the studies on that specific topic.
Sounds impressive, yeah? Sounds very impressive. Except it isn't. Because studies on juror decision making, studies on juror bias, the vast majority of them are experimental. And this witness here said that she likes experiments. She likes the experiments because you can control extraneous variables, right? You can control for everything. Like in real life, you can't control for stuff, right? But in an experiment, you can control for any potential confounding or extraneous variables and just vary the variables that you're interested in. So let me show you some examples here. So this is my Google Scholar search. Anybody can search this. Google Scholar is open to everybody. You don't have to be an academic to look at Google Scholar. And my time frame, I've said since 2020. And like I said, I'm 3 years behind because I haven't done a search on juror decision making or anything along those lines since I left my job in 2021. So this is all new to me. So my search term was pretrial publicity meta-analysis, because I wanted to find the meta-analysis that she's talking about. And I think this is it. This seems to be it. Now, unfortunately, I can't get the full article. When I worked for a university, the vast majority of articles, I could get the full paper. But because I no longer have university access, I only have the abstract. The abstract is the overall summary. The abstract is written, it comes at the beginning of an academic journal article. Right, so the abstract is the overall summary. So this sounds like the one that the witness is talking about. It was published in 2022 and it had just over 11,000 participants. So that sounds like the right study. So this is it. The impact of pretrial publicity on mock juror and jury verdicts, a meta-analysis. All right, this is the issue, mock juror. What do you think mock juror means? Just, what do you think it means, mock juror? Does anybody want to guess what mock juror means? Okay, a random person who is asked if they were a jury, would they XYZ? For a mock trial, pretend juror, mock juror equals mock trial, research. All right. You would think that when they say mock juror, it's somebody who is participating in a mock trial. So literally a trial, like, you know, they set up a trial and they get jurors to sit in on this pretend trial. No, unfortunately not. In the vast majority, I'd say over 99%, 99% of mock juror studies do not emulate a trial of any capacity. Broken Goth Doll's got it right. Do you have some background in psychology? Because it's not a mock trial, just a questionnaire to ask the mock juror what they would do. Exactly. Over 99%, I haven't counted, but the vast majority are questionnaire studies where you say to somebody, if you were a juror, like, or the phrase is consider that you were a juror, and then they give you a what they call a hypothetical scenario, and that can be as few as 100 words, so a tiny snippet of information, and you are asked to pretend that you're a juror based on a hypothetical scenario that could be as little as 100 words, could be more, and then you're asked questions on it. That's what the vast majority of mock juror studies actually do. So any research that comes from that type of research lacks what we call ecological validity. What's ecological validity? Ecological validity is real world application. Is it valid in the real world? Are my results valid in the real world? And I would say that all mock juror studies they're fundamentally flawed because they lack ecological validity. And I promise you, I used to do this research. Forgive me for my sins. Oh, Lord, please do. Because I used to do this kind of research because it's easy. And I do agree with the witness in that they do have some benefits. These mock juror studies do have some benefits because what you're able to do is statistically compare two or more very controlled conditions. So I might say to, let's say, 100 people, I might say, consider if you were a juror on this trial, and then give them a hypothetical scenario. And unbeknownst to these 100 people, there's actually two different versions. There might be more. But let's say 50 people in my study get a hypothetical scenario that depicts a male perpetrator for this particular crime, right? And then the other 50 get a hypothetical scenario which is identical. It's word for word, absolutely identical, but it's a female perpetrator. So what I would then be able to do, because I've got all my variables constant, I'm able then to statistically compare perpetrator gender, like without any confounding variables. That's the idea. That's what this witness is talking about when she says experiment. All right, so that's the meta-analysis. And it's looked at mock juror and jury verdicts. All right. So the other important thing that you need to consider when you're looking at mock juror studies is that the majority of them are mock juror studies, Juror, like juror. So one juror. So you are asked to consider, so you personally are asked to consider, if you were a jury member, how would you react? to this hypothetical scenario, and then you're asked for some questions. All right. But you're also asked not to confer with anybody. So even less ecological validity, because any responses I get are based on one individual person. Well, in a jury, there's 12 people deliberating. There's only 6 if you're in Florida, because I found out with the Ashley Benefield trial that they only have 6 jurors in Florida, unless it's a death penalty case, which I found bizarre. But we have 12 here in the UK. I think in Scotland they have 15. Is that true? I heard somewhere that there are 15 jurors in Scotland. Anyway, so mock juror studies are just looking at one person's opinion. One person's opinion. All right. Mock jury studies are a little bit better in that they actually try to emulate the group decision making that happens in a jury deliberation room. But those are few and far between. Those studies are few and far between. And they still don't give you ecological validity because they're asked to consider a scenario rather than go through an entire mock trial. Do I think Anne wanted to do mock studies but was advised against it because of the pool being so shallow? I don't know what you mean by the pool being so shallow. All right. Okay, so this study, I'm not going to read all this because it's I'm gonna cuss only a little bit. When I was an undergrad, I had a social psychology lecturer called Barry, Irishman, Barry McCarthy. He was great, fantastic. He's the guy that made me fall in love with social psychology. But his opinions of statistics in relation to social psychology was, put shit in, you get shit out. So even though a meta-analysis is considered a high-level statistical test, so meta-analysis studies are considered high-level studies and get published in, high-profile journals. If all the studies that have been used in that meta-analysis are a bit rubbish, then your meta-analysis is also going to be a bit rubbish. Shout out to Barry. I don't even know whether Barry's still with us, because he retired when did he retire? I'm going to say 2012. And he was 65 then, so 12 years. So he's going to be in his late 70s now, so he's probably still with us, Barry. All right, so the objective of this study, we updated and extended a meta-analysis on pretrial publicity published by Shebley et al. 1999 to re-examine the effect of negative, so anti-defendant pretrial publicity on individual juror and deliberating groups' jury verdicts, and the effect of positive, so pro-defendant pretrial publicity on individual verdicts. All right, so what did they find? Okay. All right. So for methodological variables, we hypothesized that published studies, community member participants, so these are just random people, and crime-related comparison conditions would have a stronger pretrial publicity effect. Okay, whatever. All right, so we analysed 77 unique effect sizes extracted from 27 published and 18 unpublished reports. So they had 27 published studies and then 18 unpublished reports. So what are unpublished reports? These could be like master's theses. So they're unpublished, so they've not even gone through a peer review process. That's a problem. So from 18 unpublished studies, so why did they use unpublished studies? Why not just the 27 published studies, which at least have gone through peer review? No idea. Results. Negative pre-trial publicity increased juror guilty verdicts, but those are in mock juror studies. And then the effect size is 0.16. That's a tiny effect size. That's probably in a sample size of 11,000. That's probably not even statistically significant. That's a tiny effect size. And jury verdicts, that's a moderate effect size. Whereas positive pre-publicity decreased guilty verdicts. Again, that's only a small effect size. What's going on here? All right. So I wasn't impressed by that. But then again, I only had the abstract. Maybe I'd be more impressed if I'd read the actual study. But I had a look at a few of these because I haven't seen any of these. All right. So effective pre-trial publicity via social media, mock juror sex and rape myth acceptance on jury decisions in a mock sexual assault trial. Okay, interesting. This is exactly the stuff I used to do. All right, determining the influence of irrelevant victim information on potential jurors is particularly important in the current age of social media. The present study explored the effects of pre-trial publicity concerning the complainant, shared via social media posts, mock juror sex, and rape myth acceptance on mock juror judgments in a sexual assault case. 156 community members. So this was a study on 156 people from the United States. So 77 males, 78 female, 1 declined to answer, over the age of 18. So to view either pro-complainant or anti-complainant or control messaging on social media. So the complainant is a victim. Before reading a mock juror, a mock sexual assault trial transcript. So they had probably a hypothetical scenario that was a little bit more detailed than a 100-word scenario, but still. So results indicated that participants in the anti-complainant condition were significantly less likely to select a guilty verdict compared to the control condition, whatever. All right, so that's a rape myth acceptance study. All right, this could be interesting. Your bias is rubbing off on me. The impact of pre-trial publicity and jury type on guilt decisions, trial evidence interpretation, and impression formation. Interesting. All right. Pre-trial publicity can bias jurors' decisions. We know it can. We know it can, but that's the reason why we do voir dire. That's the reason why jury selection takes place. Surely. All right. The courts often assume such bias can be ameliorated or reduced by jury deliberations. The study explored the effect of pre-trial publicity, anti-prosecution, anti-defense, or no pre-trial publicity, and jury type, pure versus mixed, on mock jurors stroke juries. So this is looking at actual jury verdicts. So this is stronger. Potentially this is stronger because this is looking at actual jury verdicts. This doesn't appear to be one of those mock juror questionnaire studies. So this is looking better. Impressions and trial evidence interpretation. Pre-trial publicity affected pre-deliberation verdicts, with anti-defense jurors being the most likely to render guilty verdicts and anti-prosecution jurors the least likely. That's common sense. At the jury level, only the pure anti-prosecution juries, all jurors read. Oh, no. It is a mock juror study. I was thinking that because it had a bigger sample size, like 495 to 96. So is it 495 or 496? Who knows? I was thinking that it might be actual trial evidence, but no, it's not. It's not. It's a reading and then answering questions. showed evidence of pre-trial publicity bias by being the least likely to render guilty verdicts. Comparisons of pre- and post-deliberation verdicts revealed that deliberating on pure juries increased pre-trial publicity bias. This effect, blah, blah, blah. All right. All right. Let's do one more. The social influence of pre-trial publicity. So what's this at? Well, this is someone's thesis. Oh, this is someone's, oh dear. This is an undergraduate thesis. This is an undergraduate thesis. Oh, dear Lord. So it explores the different forms of pre-trial publicity, including negative and positive, that impact juror biases and potential influence. This research identifies the psychological reasoning behind the social influence of pre-trial publicity. Okay. We'll do one more. What's this? What drives a jury deliberation? Study explored how pre-trial publicity exposure and jury composition affect the slant and content of jury deliberations. It compares jury deliberations, so 63, composed of 333 jurors, quote unquote, who were exposed to the same type of pre-trial publicity. Have I read this one? So they're all mock juror studies. Oh, the Western District of Washington recently developed an educational video to reduce jurors' implicit biases. Little is known regarding the effectiveness of this proposed remedy to address a range of implicit biases. This study tested whether this educational video reduces pre-trial publicity bias. A total of 330 undergraduates, these are undergraduates, these are like 18-year-olds, were randomly assigned to read pre-trial publicity or unrelated articles. An average of 9 days later, they were randomly assigned to watch the educational video prior to viewing a murder trial. So they actually watched a trial. Oh, good. So they actually sat them down and made them watch a trial. Be interesting to know which one. Those exposed to pre-trial publicity were more likely to convict and found the defendant more culpable and less credible. The educational video did not reduce bias. Oh dear. The educational video did not reduce pre-trial publicity bias. A more tailored debiasing strategy may be needed to overcome the biasing effect of pre-trial publicity. So that's better study, that they actually got them to watch a murder trial. But whatever intervention this educational video was meant to show didn't work. So at least they were honest about that. All right, let's go back to this trial. So the point I'm making here, is don't be fooled by impressive sounding language, because the vast majority of research in social psychology in relation to juror biases, in relation to all this stuff that this social psychologist presented, are usually 99% of them are questionnaire studies. Now, look, I'm not completely poo-pooing them, because if you have a whole bunch of studies that basically all show the same thing, you know, different samples, different locations, different time periods, then you do have a signpost that there might be an issue here. And we all know that pre-trial publicity can influence potential jurors. We know it can. But the question for Bryan Kohberger is being in Latah County, given that in Ada County, where they want the trial to go, the media is almost at the same saturation level. So from a psychological perspective, yes, negative pre-trial publicity could have an influence on people's opinions. Yes, it can. It can. However, what it doesn't tell us is anything about the real world situation in Latah County. It doesn't tell us anything about who's actually viewing this media. In either Latah County, where 36% of the media volume in that local area is about Bryan Kohberger, and then 34% of it in Ada County, almost the same. If we don't know whether people are actually attending to that media at all, then any psychological evidence about the influence of negative pretrial publicity is rendered moot. Think about that. Think about that. All right. Okay. Next timestamp. We're going to move on to the next person. So 250. Now this next person she was on for quite a while. So this next person he's spoken before. He's the one who did the jury questionnaires for the defense. So the defense sent out some jury questionnaires. So this guy actually is no longer talking in the hypothetical. This guy I actually listened very attentively to, because this guy has actually done some research in the population where Bryan Kohberger is going to be tried. So whilst we can say, yes, there's lots of media about Bryan Kohberger, but it doesn't tell us anything about people's attention to that media. And we know, hypothetically speaking, theoretically speaking, pretrial publicity can have an influence on juror perceptions in experimental studies. What we have nothing on at the moment is, what does that mean for Bryan Kohberger? So the best chance we have of understanding what this means for Bryan Kohberger is by listening to this guy, who has actually done some juror questionnaires in Latah County. So I've got a couple of timestamps for this guy. He's spoken before at prior hearings. How do you poll people for their level of relatability to a potential criminal? Depends what you mean by relatability. So I'm going to let this guy introduce himself. He will be familiar to those who've been following Bryan Kohberger's pretrial hearings. He has spoken before.
Penalty of perjury.
I did. All right. So please have a seat, and then please state your name and spell your last.
You're going to speak slow today, I promise. So Bryan Edelman, Edelman.
Sir, go ahead. Stand up.
Thank you. Good morning.
Good morning.
Dr. Edelman, I see that you brought some things to council table with you.
I did.
What do you have?
It's just a copy of my presentation.
Your PowerPoint presentation? Okay. And is that face down? Perfect. Will you let me know if you need to flip it over to refresh your memory?
I can tell you the second you start, I won't be able to see anything, so never need it.
Okay. Your Honor, and counsel, then I'll ask if he can leave his PowerPoint presentation face up so he can help us understand his testimony. No objection to that.
Okay, thank you. Go ahead.
All right, let's start with your background.
Going back how far? Let me try it.
Well, let's start with what you do right now and then work backwards and forwards. How about that?
Okay. I'm a trial consultant. So in that capacity, I'm often in a courtroom doing jury selections and assisting with that, running juror questionnaires, helping attorneys craft the oral voir dire questions. And I also do pretrial research. So that's focus groups and mock trials. And then I also do post-trial interviews
and do a lot of presentations and writing and kind of trying to educate or help the legal community. And then I also serve as an expert witness in this capacity. And in that scenario, I'm often focusing on pretrial publicity, the impact of pretrial publicity, and whether or not a defendant's due process rights may have been undermined by media coverage. And I also do post-conviction work, which kind of ties into that, where I might be brought in to look at a case to see if there was a lot of media coverage and whether or not there should have been a change of venue or a request for a change of venue, and looking at the adequacy of voir dire to uncover what jurors knew. So that's kind of reviewing the voir dire transcripts and use of challenges and that sort of thing.
How long have you been doing that work?
That part? Since I think the first one, maybe like 2011, 2012, something like that.
All right.
Where do you do that work? What company?
So all over the place. So all over the country. And
All right. So he's a jury consultant. So he works, I'm guessing he works for the defense most of the time. If he's looking at things like post-conviction relief. In this case, right, he's got lots of experience doing things like jury questionnaires that are sent out, like in this case, were sent out on behalf of the defense. So send them out to a whole bunch of people, of eligible jurors in Latah County, and see what results they get back. So that's more valid to me than talking hypothetically about the psychology of this stuff. This makes more sense to me than just looking hypothetically at pretrial publicity. Like, what do people in Latah County actually know about Bryan Kohberger? That's more interesting to me, right? Because it tells us a little about how people are responding to the media in that's out there. Okay. That said, he does have a bias because he's being paid by the defense. Does that matter in this instance? Maybe. Maybe not so much his results, but certainly the way that he interprets those results, potentially. All right. So let's go to, I've got 2 timestamps for this testimony. So we're going to 250. And then we're going to skip all the way to 626 after this. So I'm going to play a couple of minutes at 250. And then we are going to jump all the way to after lunch. Loving it. So this is his PowerPoint. Impact of pretrial publicity on jury decision making. Okay, let's go a little bit back. Oh, we'll stay there.
All right. Let's go to the background of why we do this, why this matters.
yeah, so there's decades of research in general documenting the impact of pretrial publicity on decision making, and it kind of falls into 2 areas. So there's what we call field research, which is kind of similar to like a change of venue survey. So people are exposed to pretrial publicity in a naturally occurring setting. I read a newspaper, I watch it on the news or on the news when I'm cooking dinner, whatever it may be. And so we see natural exposure, and we're able to assess the impact of that coverage on pretrial opinions. But there's some limitations to that. We can't really learn how pretrial publicity impacts decisions, and we can't really learn the types of pretrial publicity that are most impactful, and whether or not remedial measures like an admonition or voir dire mitigate the impact it has. That's where experimental research comes in, because it's a controlled setting and we can test things like what types of pretrial publicity are most prejudicial, how does pretrial publicity impact decisions, and things like do remedies work and so on.
All right. Yeah, except, as I've already said, the experimental research is mainly mock juror studies that are just questionnaires to random people. And actually, the majority of those mock juror studies are done on undergraduates. because they're right there. So if a university lecturer or professor is doing a study on mock juror decision making, the people who they're most likely to come into contact with are undergraduates. So even more reason to say this lacks ecological validity. Now, the field research that he's referred to here is more like what he's done in the Bryan Kohberger case, that he's actually sent out questionnaires to the people who are in that county who are eligible jurors. So although his field research is interesting, he's right in saying it doesn't tell us why. We'd have to go to the experimental research to learn why these things happen. But again, the majority of that experimental research lacks all ecological validity. So we're stuck between the rock and a hard place here. And I'm not throwing out the entirety of social psychology. I'm not saying that at all. I'm just saying we have to be aware of the limitations of this research, because the majority of it is using hypothetical scenarios, using undergraduate samples. So we have to be very mindful of that. All right, I'm going to skip now to after lunch. Now, they had to stop. They had a long break because he was going to start showing stuff that they didn't want in the public. And it turns out that it was stuff about social media, like, I don't know, Facebook groups and stuff like that. Like, he started to scroll, like he'd done a little screen grab of him searching Facebook for all like the Facebook groups on Kohberger, and the judge stopped them. Then they had to have this long conversation. They went for lunch, and then the first like 15 minutes of the hearing after lunch wasn't on camera. They didn't want it in the public, and it was to do with the type of social media that had been out there for Kohberger. So when I'm skipping to like 6 hours and 26 minutes, it's because they had such a they had time for lunch. There he is. He's scrolling through all of these articles on Facebook. This case has generated significant content and discussion on social media. And the judge was like, no. So the lunch break was pretty extensive. So it didn't actually go for 7 hours. It was a long lunch break. But I'm going to skip. What's this? Oh, these are the key findings. Let's just have a listen to this. This isn't my timestamp, but it would be probably useful to listen to this, because this is the methodology and the basis of what he found in his juror questionnaires. So these were sent out to eligible jurors. So it was a digital telephone survey. So basically, a random digit telephone survey is that they just call random numbers in that county. And then whoever answers gets asked these questions. Right? So it's random in the respects that anybody could be phoned. Anybody in that county could be phoned. And then whoever answers, I assume they have to make sure that they're an adult and blah, blah, blah. So are they eligible for jury duty? Criminal justice attitudes, case awareness, and do they already have prejudgments about Kohberger? And then demographics, so the personal details like age, gender, socioeconomic status, ethnic origin, nationality, those kind of things. All right, they ask them as well. All right, so let's listen to just a couple of minutes of this, even though it's not on my timestamp. But I think this will give you a little bit of background if you didn't watch the prior hearing, because he was in a prior hearing. It's a while ago now where he presented these findings. So this is just kind of recap.
So if somebody maybe is at work, you still have a chance of being included in the survey. There's soft conversion techniques. So if somebody's kind of on the fence, like maybe they're like, maybe I'm busy, can you call me back? We try to find out when can we call you back so we can talk to them later, just to encourage them to participate and not drop off. So all of that stuff is done to increase response rates as best we can. And that's all starts with the introduction. And then the follow-up introduction or instruction kind of is similar. It explains there's no right or wrong answers. They're not forced to say yes or no. They can say no opinion, I don't know. They can refuse to answer the question, all of those things.
Now, this is another issue for real life relatability, because even though they're ringing like a random sample within that county, it's voluntary. So they might say, look, I don't want to take part. I'm not interested in Bryan Kohberger, so I don't want to take part. I'm sick of hearing about that guy. I don't want to take part. I'm too busy. Or they might say, oh, ring me back later. And they basically put them off and put them off and put them off because they're too nice to say they don't want to take part. They're not like me. Someone comes to my door. I don't answer my phone anyway, so they'd never get me on the phone. But if someone comes to my door, I'm pretty rude. I'm pretty abrupt. So some people don't like to be rude. Some people will say, oh, yeah, you can call me back later. And then they don't answer the phone because they're not interested. And for them who actually agree to take part, they might not answer all the questions. So this instills a bias in his results. So even though his results are more valid than hypothetical scenarios, just of random people reading random pieces of, mock trial transcript or whatever, a short story depicting a crime. So it still doesn't tell us how many people could potentially be biased, because the people who have no opinion, the people who are not interested, won't take part in this survey. So his answers, his responses, his results are going to be biased towards those people who do have an interest in this case. Think about that. Think about how that will influence the results that he's going to present.
Can they answer some questions and not others if that's what they want to do?
Absolutely. That's called a refusal. So they might say, I don't feel comfortable answering that question.
All right. So yeah, it's voluntary. They can agree to take part and then only answer a quarter of the questions because they don't want to answer the others. So this, although this is a field study, this is in the county that Bryan Kohberger is going to be tried, it's still got its problems. Bear that in mind. Also, the other thing that we need to think about here is that's not the case for people who are chosen to be a potential juror. Like when they send the actual jury questionnaires out, when eventually it's that time, the people who would refuse to take part in a survey because they've got no interest in Bryan Kohberger do not get that option. They're told to turn up. They've got to take part. It's your civic duty to take part if you're chosen to be on a jury panel. So they'll get a whole bunch of people in and then whittle it down and whittle it down and whittle it down based on voir to the number of jurors that they want. So how do we know that the people that get chosen to be brought in for that voir process, how do we know that the majority of those people have actually had no interest in Bryan Kohberger and therefore are not reflected in these survey results? Think about that. All right, these are the key findings.
You can see that 52% believe that he should be sentenced to death.
When I look at this slide and
All right, so we've got case recognition and presumption of guilt. I'm going to read it off my other screen because it's bigger. All right. I'll wait for it to come up because YouTube's a little bit behind StreamYard. I think I can read it from this. Case recognition and presumption of guilt. Read, seen, or heard about the case. So this is comparing. Oh, there we go. This is comparing people in Latah County with Ada County. So read, seen, or heard about the case. 98% in Latah County and 93% in Ada County. So again, virtually the same. So they want to send the trial to Ada County, but again, the majority of people in Ada County have heard about this case. But again, we have to remember that these are people who wanted to take part in this survey. These are people who probably have an interest in this case to begin with, because those who had no interest in the case probably refused to take part, said, look, I'm too busy. I'm not interested. I'm sick of hearing about this guy. So that's skewed, massively skewed. For those who recognise the case, which is the majority of them, so 68% in Latah County and 58% in Ada County have followed this case somewhat or very closely. 67 versus 68 believe Bryan Kohberger is guilty of murder. So more people in Ada County actually believe Bryan Kohberger is guilty than those in Latah County. Now, bear in mind, that's only 1%. That's probably not nowhere near statistical significance, but still, as many people in Ada County as in Latah County believe Bryan Kohberger is guilty. So why change the venue to a county where just as many people who've had an interest in this case believe he's guilty? Believe Bryan Kohberger is definitely guilty. 25% versus 22%. Again, negligible. Reported that Bryan Kohberger would have a difficult time convincing them that he's not guilty. 51% in Latah County and 56% in Ada County. So more people in Ada County would have a difficult time being convinced that he's not guilty. What insanity is this? Sorry, I'm going to have to just take the... Believe Bryan Kohberger should be sentenced to death. 52% versus 49%. So the Ada County and Latah County results are virtually the same. So why change the trial to a county where the results are virtually the same as they are in Latah County? Why go to all that time and expense to change the venue when the results are virtually the same? Now, again, bear in mind that these results are going to be skewed to the positive because these are going to be people who voluntarily wanted to take part in this survey. The reason why they wanted to take part in the survey is because they've got an interest in this case. And we know that because we've got 98% and 93% said that they did know about this case. They'd read about this case. Those that didn't wouldn't have taken part in this survey, so are not represented in these findings at all. Think about that. All right. I am going to go to my timestamp now. Okay, 6:26. 6:26. 6:26. I don't even remember why I chose this timestamp. Must be some interesting. I'll go back just a minute. All right, let's listen to this. Oh, I know why I wanted to look at this. Let me just go back a little bit further. All right. So, have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Okay, so the results were only 8% mentioned this detail when asked, what have you read, seen, or heard about this case? However, 72% of survey respondents who recognised the media item reported that Kohberger was guilty, compared to 47% of those who did not recognise the denial.
And people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it. This is what you see.
So this timestamp's interesting because what Ann Taylor is getting at here is the jury selection process. So when participants are asked, have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? 72% of the respondents said that they recognised that media item. However, when asked, you know, an open question, what have you heard or read about this case? Only 8% of them mentioned the knife sheath. So the argument here is that voir dire is not going to weed out all of the people who have implicit bias, who have heard things or read things that they know, but they're not, it's stuff that doesn't immediately come to mind, such as the knife sheath doesn't immediately come to mind when you ask a general open question like, what have you heard? You know, tell me everything you've heard about this case. But yeah, it's very incriminating. The knife sheath with the DNA on it is very incriminating. So the point that Ann Taylor is getting at is even voir dire is not going to be able to weed out all of the people who have heard stuff, who do know stuff about this case, that it's stuff that's incriminating, but it doesn't readily come to their mind. So they're not purposefully like lying at the voir dire process, but it's only later that those potentially incriminating things come to mind. I've got a problem with that as well, because this is based on the survey of people who have voluntarily agreed to take part in this study. Okay.
All right.
So the next question is, can you set aside what you know about this case and be fair and impartial? That might be something that people are asked at voir dire. All right.
The magic question, can you set it aside and be fair and impartial? Is that going to work?
I'm sorry, what's the question?
Is this going to work? This question.
Yeah. So you want to, what is this a good question, bad question?
Will it work? Will it help
Will
us?
it work? What does work mean? I don't know if you think about that.
Help us find an impartial jury.
No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And it's not, there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not.
Now, whilst I don't disagree with what he's saying there, we can't tell this from his study. We can't tell this from his study because it's voluntary. And the people who have no interest in the case, who may well end up on the jury, right? Because jury selection is involuntary. You turn up. If you're called, you turn up. Simple as that. Or else you're held in contempt or blah, blah, blah. All right. Here in the UK, you get a jury summons and you can delay it for a certain time. Like, let's say, for example, you had a holiday booked for the time that they tell you to turn up. Then you can write to the court and they'll delay it for you. right? So you turn up at a later date, but you don't get out of it. You do not get out of it. You just have to come to a later, a later trial. So you don't get out of it. So you're told to turn up whether or not you've got any interest in being a juror, whether you're terrified of being a juror, or whether, like me, it was the best thing that ever came through the mail because I've always wanted to be on a jury. And then, hey, I get picked for a murder trial. That's the best day ever for me, right? But not all people want to go to jury service. It's time consuming. It takes them out of their real life. They have to take time off work. They might lose money. Like if they're self-employed, they might lose money. And what they give you for expenses does not cover somebody's, salary. It doesn't. So there's lots of reasons why people don't want to do jury service. But those people are not the same as the people who took part in this study. So even though this is better because it's based on people in Latah County who are eligible to be on Bryan Kohberger's jury, or Ada County if it gets transferred there, it's still not without its problems because these are people who responded to this survey who wanted to take part in this survey. So not the same group of people, not the same as people who will turn up for the jury. So although I don't disagree with what he's saying here, we still have to have that very important thing in mind that you're asking people who want to take part in a study. You're not asking, you're not going to get the same response necessarily to people who turn up at Vodia who have no interest in the case. They probably can be impartial because they've got no interest in the case. They haven't followed the case. So we still don't know, after all of this entire day, we still don't know how many people have actually attended to the media that's been out there in Latah County or in Ada County. There might be loads and loads of media, but we don't know how many people have actually attended to it. We don't have that answer.
So there's no data to support that.
And do you have an example to tell us about?
So this is some research I did on this question to see how people respond to it. And so what I did was I went to a Facebook page that was about this documentary on HBO that got a lot of attention called The Jinx. The Jinx was about a person named Robert Durst who had been a suspect for multiple murders. For his wife, he went to trial in Texas for murder, and then a good friend of his in California was killed, and he was suspected to be involved in that as well. What was unique, he was from a very wealthy family in New York, so it captured a lot of people's attention. And there was this mini-series on HBO. And at the end of it, they confront him with some evidence that would suggest he was involved with his friend Susan's murder. And he takes a break and he goes into the bathroom and he forgot that he was wearing a microphone, and he pretty much confesses. He says, "Of course I shot them all," or "Of course I killed them all." He's talking to himself. So it was a highly prejudicial documentary. And later on, he was charged with the murder of his friend. So what we did was we went to...
Unfortunate. That is the definition of a hot mic moment. All right, so that's the example that he used, Robert Durst. Don't know the case.
To this Facebook page where people had made public statements about the defendant that were highly prejudicial. So this is just one...
But this is a rubbish study. I'm sorry, Mr. or Dr. Edelman. This is a rubbish study because this is based on what people said on Facebook about this guy, Robert Durst. Well, you make a choice. You're not going to go on Facebook if you've got no interest in the case. You're not going to be talking about Robert Durst if you're not interested in this documentary. So why is this relevant? Again, it sounds great that, oh, I've got this evidence, I've got this example, and this shows exactly why we have to change venue. No, it's not even close to being the same situation.
One example, someone said This is a true version or vision of a sociopath. I'm physically ill over the conclusion. I'm beside myself. I was overjoyed at the news that he was arrested. So if somebody said this in public about this case, I think we'd all agree that person probably can't be fair. You're publicly stating it to the world. You think he's
no? That person couldn't be fair, probably, but they wouldn't be chosen to be a juror, would they?
sociopath? So we recruited people that made these extreme comments on this page and went through a survey. And we asked if they knew about the case, whether they thought he was guilty, what they knew, and so on. You can see, as you'd expect, almost everybody we recruited who made these public statements reported that Robert Durst was guilty of murder, 92%. And reported strong opinion. 77% of the people we've recruited said that he could not change their mind about his guilt. So almost everyone. And then we asked those closed-ended case recognition questions, and many of these are either inadmissible or very prejudicial. You know, that he was like a suspect in his wife's disappearance. Probably not admissible in a different case. His murder trial in Texas. We asked several of these. And the confession, the captured confession, you see 100% knew that, which is considered like the most prejudicial thing that can be in the media, according to the Supreme Court. And so what we'd expect is that these people would say, I cannot be fair and impartial. There's so much bias that they're demonstrating. So we give them the magic instruction that you often see. This came from a transcript in a high-profile case where the court had explained the burden of proof and that the defendant's entitled to a fair and impartial trial, and that the law requires that you set aside everything you know and only rely on the evidence, common things you hear. And all these people who express all this public bias and all this vitriol and reported that he's guilty and you can't change their mind, by just saying that to them, magically report that they can be fair and impartial. 81% said they could be fair and impartial after hearing that instruction.
All right, so giving them a jury instruction changes them. So it changes 81% of them from saying, no, I can't be fair and impartial and he's guilty and he confessed, blah, blah, blah. When they read the jury instruction, 81% of them magically said that they could be fair and impartial. So the argument is making here is all of these people who've been on Facebook saying all of these nasty things about Bryan Kohberger also, if given a jury instruction, would say, oh, yes, I can be fair and impartial, even though they've made a lot of negative claims about Bryan Kohberger. Great. That seems to be very damning and the reason why they need to change from Latah County. But actually, it doesn't tell us anything. It doesn't tell us anything about changing the case from Latah County to Ada County. Because if we go back to the key findings, go back to these key findings, as many people in Ada County believe Bryan Kohberger to be guilty as in Latah County. So, and also, if we take a study like this Robert Durst one, where they get a jury instruction, and then magically, after this jury instruction, they're able to become fair and impartial. Well, that doesn't just have implications for Bryan Kohberger's trial. It has implications for every single trial that exists, regardless of where it's held and regardless of the case. So what this guy has actually made an argument for is the ending of jury trials, because juries can't be fair and impartial. That's basically the upshot of what he's saying. However, I don't think they should end jury trials. They're not perfect. They're absolutely not perfect. There's always a bias against the defendant, because when you are seated as a juror and the defendant's there in the dock, your first thought, and I say this not as a psychologist, but as a previous jury member. So I sat on a jury of 2 men who were accused of murder. This was back in February/March of 2020. It was just before our lockdown here in the UK for COVID. And I honestly thought, my first thought was, well, they're in the dock for a reason. That was my first thought. My very first thought was they're in the dock for a reason. And then I checked myself and I said to myself, that's bias. I am biased. But I can guarantee that every single person who sat beside me in that jury box was thinking the same thing. So you're already, as a defendant, you're already on the back foot, because every single jury member looks at that defendant in the dock and thinks you're there for a reason. And that's unfair. And I checked myself. And I was able to, once your implicit bias becomes conscious, then you're able to keep it in check. So the question should be, from a psychological point of view, is we all know that when juries sit down, they have a bias. So what can we do to make conscious people's implicit bias? But that's across the board. That's in my country as well as in Latah County, because that's just a part of the human condition. That we look at a defendant in the dock who is on trial for murder, and your first thought is they're there for a reason. That's a thing that needs to be kept in check. So, yeah, the vast majority of people can say, yeah, I can be fair and impartial. And many of them can be, regardless of what they know about the case. But none of what was presented by the defense, even though it was impressive, and these are experts, none of it convinced me that they needed to move that trial out of Latah County. And I say that from somebody looking at this with a psychologist's hat on, and also coming at this from someone who has no horse in this race. I don't care whether they move it to Ada County. I don't care whether they keep it in Latah County. I don't think it's going to matter to Bryan Kohberger where they hold this trial. Because the things that they presented here in this hearing tell me that there are issues with jury trials. But it doesn't tell me that there's a specific problem with Bryan Kohberger's trial above any other. So just because Bryan Kohberger's got a defense who's prepared to, have hearing after hearing after hearing and bring all of these experts, it doesn't increase my confidence that Bryan Kohberger will get a fair trial anywhere else. But it also doesn't make him different than any other defendant. So I'm going to play you now, finally, what the state said. And again, I've no horse in this race, but I just wanted to play what the state said, because everything else has been from the defense perspective. So even though the state did cross these witnesses, they didn't put on any witnesses of their own. And I'm disappointed. I'm disappointed that all we got was a closing statement. And I've forgotten what my timestamp was. Hold on. 7:30. Where's HeyJB again? 7:30.
That we have is to protect Bryan Kohberger's constitutional rights, his right to a fair.
So that's Ann Taylor. She's just summing up here. All right, we'll start then. It's not going to go in between.
That we have is to protect Bryan Kohberger's constitutional rights. His right to a fair trial is as important as our right to free speech our right to bear arms, our right to be free from unreasonable searches and seizures, and the right to a fair trial cannot happen in Latah County. There is way too much media coverage. It is biased media coverage. It has impacted the potential juror, and it causes bias in the potential juror. This is a tiny little community, and this case needs to move where there's a chance to get jurors that haven't prejudged guilt of Mr. Kohberger and will have the ability to be anonymous and not known by everybody else in the community. The pressure to convict here is great, and it won't be in Ada counties. The venue needs to be changed.
Well, although I agree with her that it's going to be very difficult for Bryan Kohberger to get a fair trial, I don't think her witnesses have convinced me that he won't get a fair trial in Latah County, but he would get a fair trial in Ada County. I haven't been convinced by her witnesses. Anyway, this is the state.
Thank you, Ms. Taylor. Ms. Beatty?
Thank you, Your Honor.
Your Honor, the case law in this case just does not support a change of venue, given the evidence that the court has before it. The state does not disagree with counsel on what the appropriate standard is. The appropriate standard is that the defense has the burden of showing a reasonable likelihood that the defendant's ability to get a fair trial is going to be diminished as opposed to some other county, or put another way, a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So in looking at the evidence the court has before it, we can start with Exhibit C. Those were the charts presented by TrueScope. And we can see in those charts that for at least 6 months on one of those line graphs that compared Ada County and Latah County, Ada County had significantly more coverage than Latah County. And that more recently, in the past couple of months, that line graph comes together again, and they're just a couple points off. The fact is, Your Honor, this case has media coverage everywhere. That is something that was acknowledged by the defense, and that is something that is abundantly clear in these surveys. So looking to Exhibit C, comparing Latah County and Ada County, it is clear that this could easily be a back and forth scenario where at some points Latah County is higher and at other points Ada County is higher. And it almost looks like we may have recently been headed in that direction as recently as a few weeks ago. In looking at the survey numbers, Your Honor.
Yeah, like I said, the figures for the media coverage in Latah County and Ada County are virtually the same. So why move it to Ada County based on the media volume? It doesn't make sense to move it to Ada County based on media volume. But again, that tells me nothing about the amount of people who are attending to that media. The amount of media is secondary to, well, who's actually watching this media? Who's really engaging with this media? Doesn't tell me anything.
I'd like to talk about what these numbers from the survey actually say.
Exactly, Harry Potter's beard. How does any defendant get a fair trial by this logic? Exactly. They're making a case. The defense is making a case for the impartiality of every juror, and how we counteract that. And there isn't an easy answer. Every defendant is on the back foot when they come into court and sit down for the first time in front of that jury. Every defendant is on the back foot. Bryan Kohberger is not special, even though he might like to think he's special, and his defense might like to think he's special. He is not special. He's no different than any other defendant. He is going to be on the back foot. Simple as that.
And I'd like to start by looking at defense exhibit F1, Dr. Dare. We don't dispute any of the testimony.
Well, that was the fourth witness, Dr. Dare. It wasn't spelt like Dare. I think it's Dahir, but I didn't play anything from that witness because she didn't really give me anything more. She didn't really give me anything more than what the others did.
That she gave today, we don't dispute anything in her declaration. And one of the things in her declaration that she discussed was a 5% margin of error in surveys such as this, with a 400 survey respondents in a population within the range of our population in Lake Talk County and in the population.
Yeah, our statistics. So saying that there's a 5% margin of error might be correct statistically, but it's irrelevant when it's a voluntary study. Because the people who have no interest, as I said before, the people who have no interest in Bryan Kohberger will have refused to take part in the study. And that's borne out by the study's own figures. That 93% in Ada County, 98% in Latah County knew about the case. The people who chose to take part in the study knew about the case. And they chose to take part in the study because they knew about the case. Crazy.
Population of Ada County. So if we're talking about a 5% margin of error, according to the defendant's own expert, and we're looking at case exposure in Latah County of 98% and Ada County of 93%, those communities are within the margin of error. Looking at presumption of guilt.
Well, yeah, they are. And 98% versus 93%, it's not going to be statistically significant, especially with a 5% margin of error. But he didn't present any statistics. He presented figures, but no statistics to look at the statistical differences. That's a big problem for me.
Guilt among jurors who knew about the case. Latah County, 67%. Ada County, 68%. Canyon County, 69%. And Bannock County, 76%.
So the other two counties that I didn't talk about, but Bannock County and Canyon County, those are smaller counties in between Latah County and Ada County. So the defense wants it moving to Ada County, but they won't object if the judge prefers to move it to a closer venue of Barrett County or Canyon County. They won't object to that. They just want it moving from Latah County. But why they've chosen Ada County makes no sense to me when the figures are almost identical and are going to be statistically non-significant between Latah and Ada County. I don't understand why they've chosen Ada County as their first choice. But anyhow, it doesn't matter where it's going to be. It's going to be difficult to seat a truly impartial jury wherever you go. And that's not special. Bryan Kohberger's not special. That's the same the world over. It's difficult to seat a truly impartial jury regardless.
Latah County.
Yeah, Ada County had their bell, yeah.
Ada County and Canyon County are at best within the margin of error. And if these results are to be taken literally, Latah County has the lowest number of jurors who knew about the case who are going to presume Mr. Kohberger guilty. Now, when you zoom out and look at the survey results for presumption of guilt among all respondents, Latah County is at 66%, Ada County is at 64%, Bannock also at 64%, and Canyon at 62%. Again, you're within this margin of error here. I would also point the court to the fact that jurors among the total sample size who had no opinion about this case, potential jurors, survey respondents, Latah County had the highest number of folks who reported having no opinion about this case at 17%. Ada County, 12%, Canyon, 13%, and Bannock at 9%. And then again, jurors among the total sample who had no opinion about Bryan Kohberger, Latah County, 29%, Ada County, 25%, Canyon County, 23%, and Bannock County, 24%. Again, we have the highest number of survey respondents in Latah County saying that they have no opinion about the defendant.
Yeah, I made that point earlier. And it's crazy. It's crazy to me why the defense is making a big deal about this, because it's not convincing at all. It's not convincing. But again, these are these figures are skewed. There's going to be more people than 25% who have no opinion on Bryan Kohberger's guilt. Those people who have no opinion or are just not interested, who may well turn up for jury service because they've been called and they have to go, will have no opinion. Those people will not have taken part in this survey. Crazy to me. Why this hearing is even happening. Very interesting, incredibly interesting, but crazy to me.
When you zoom out, this is the big picture.
Did Chris from Colorado change venue? Chris who? Chris Watts? I don't know another Chris from Colorado. Chris Watts pled guilty, so he didn't stand trial. He pled out.
Sure. These are the questions that matter. The question is, which community is the most likely to give Mr. Kohberger a fair trial? We can split hairs and say, well, if this person knows this media item, then they're X% more likely to think he's guilty. That's not the big picture. Those are trees in the forest, but we're ignoring the forest. And if you're looking at the forest is which community has the least amount of bias. And there are obviously some personal connections in Moscow and to the University of Idaho. The state does not dispute that. We believe those can be dealt with through other measures short of venue change. But when it comes to bias itself.
Yeah, people who have direct involvement with the University of Idaho, yeah, don't seat them as jurors. Don't seat them as jurors. Like when I was a jury member, like the county is the county of Lancashire, but the jury questionnaires we were given, when I think 30 people were chosen as potential jurors for that trial that I got seated on. So 30 of us went away, filled in this questionnaire. It was a long questionnaire, and anybody who had any ties with the town, so this is a big county, Lancashire, anybody who had ties with the town that the murder took place in wasn't chosen. Anybody who obviously knew anybody who knew any of the police officers, anybody who had any connection whatsoever, however tenuous, with that town, wasn't chosen. And it was a town in East Lancashire that I'd never been to. I'm in the south of the county, so I had no ties whatsoever with anybody in the case, never been to the place, and never been to that town. So I was an easy pick because I had no direct ties with it. So it's easily to weed out people who have ties, close ties to the University of Idaho or even to Moscow. If they've got like family members who live in Moscow, if they live in Moscow, like not everybody who lives in Latah County lives in Moscow. So you can easily weed those people out at jury selection. I don't understand why they think that moving it to Ada County is going to help in that regard. Look, I've no horse in the race. I don't care if they move it or not. I'm just saying it's not a convincing argument to me.
Within a community, the court can take this entire 300+ page document of all of the survey responses and look at these surveys and see that this.
I think the bigger question is, do you have any opinion or ties to Odin? Wrong case. Wrong case. Oh dear God. If it turned out that Bryan Kohberger was an Odinist, I'd die.
The pervasive media coverage across the entire state has simply created some complications and difficulties. Those are not unique to Latah County.
Not even unique to Idaho. Loads of people. I think just about everybody I've spoken to in my country knows about Bryan Kohberger, has heard of Bryan Kohberger.
Productive conversation to have is how can we craft questionnaires that will ask jurors factual questions that help us identify sources of bias. For example, are you employed by the University of Idaho and how? Or did you know one of the victims? Things like that are factual that will allow us to then follow up and ask more questions. And frankly, Your Honor, the state would be willing, as we approach trial, to engage in good faith discussions with defense counsel and the court about potentially just excusing some jurors who are too factually close to the case for cause from the outset. We're willing to have that discussion. Another thing that the court can do that would address some of the concerns that were testified to regarding bias and social pressures is to allow potential jurors to have individual voir dire and outside the presence of other jurors and outside the presence of cameras or audio recording that are being live streamed. In this case, it's going to be critically important that potential jurors who come to jury duty feel like they can give honest answers and feel like they can be forthright. And in order to do that, I think individual voir dire would be very appropriate, and the court has that option available to it.
Everyone I talk to knows Bryan, Richard Allen, Cara Reid, and so on. I think Kohberger, I think there's probably less people who know, like that I speak to, that know Richard Allen or Karen Reid. But everybody knows Bryan Kohberger. Everybody knows the Idaho 4 case. Do you know what Kyle asked me yesterday? Kyle asked me yesterday. He went, "Have you ever heard of Lacey Peterson?" Because he's watching the Netflix show on Lacey Peterson. "Have you ever heard of Lacey Peterson? It's really good, this Netflix show that we're watching." Like him and his girlfriend are watching together. And I was like, "Yeah, he's trying to get a new trial." And he went, "Don't spoil it for me. That's a spoiler." I said, "Everybody knows Scott Peterson. He's trying to get a new trial. He has been for years." He went, "You've just spoiled the ending." So even Kyle, who has a moderate interest in true crime, doesn't keep up with, the past crimes like Scott Peterson. But everybody knows Bryan Kohberger. Like everybody knows Chris Watts. Like if I went out in my village and I spoke to 50 people that I saw and said, who of these names do you recognize? Like Bryan Kohberger, Richard Allen, Scott Peterson, Karen Reid, Bryan Kohberger, Chris Watts. If I said all of those names, I would say I bet 90% have heard of Bryan Kohberger and Chris Watts, but a lot less of the others. Don't know. Yeah, Chad Daybell, they still got a jury. Found him guilty. Oh dear.
I think another possibility that the court should consider, particularly after looking at Exhibit C and those line graphs where we're talking about peaks in media coverage, is sealing some potential hearings coming up. And the defense may not want to seal certain hearings for good reason. We're not asking the court at this point to seal all hearings going forward, but the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has.
I understand why she's saying it, but I was like, oh, boo-hoo, they're gonna probably seal evidentiary hearings. That'll be like, oh no, don't do that. Don't do that. I can see why they might want to do that, but I don't want them to do that. That's just me being selfish because I want to know what all the evidence is before the trial.
Has before it to alleviate some of those peaks in media coverage, because of course, part of the court's consideration is going to be the intensity of media coverage over the life of the case. And so one way that the court can address that is by sealing certain hearings, and the parties can use good faith and seal certain
Oh yeah, Brian Laundrie. Yeah, Brian Laundrie, Gary Petito. Yeah, I bet everybody knows them as well. I bet you they do. I'd say probably the same number of people have heard of Gabby Petito and Brian Laundrie as heard of Kohberger or Chris Watts. Yeah.
Motions or briefs addressing prejudicial information temporarily until the trial is complete. When we're talking about bias and individuals who come to court for jury selection, I think it's important to remember that we have to deal with what the law says. And what the law says is that voir dire and jury selection is the appropriate process for ferreting out bias. We don't get to hand wave the jury instructions that are based in case law and that are handed to us by the Idaho Supreme Court. We don't get to hand wave those and refer to them as indoctrination and act like all potential jurors are going to come to court and lie, that they can't be trusted. Now, certainly there are some human biases, but a good voir dire is the tool to address those. And we don't get to just burn the system down. That's not what we're here to do.
And that's the defense's arguments about jury bias. That's where they're heading, burning down the system of jury trials. Because if you're saying that a jury is inherently biased and can't be fair and impartial, then you have to make an argument to end jury trials. But no, Bryan Kohberger isn't special. He's not going to get a more or less impartial jury than anybody else. He's not special. Yeah, it's thundering here, CW. I just heard it thundering. It's fair way away, though. But yeah, I just heard it thunder.
We have to use the voir dire process. I would also point out that when we're looking at, well, actually, Your Honor, let's talk about some numbers. Let's assume, we've heard a lot about the Daybell case. Let's assume that this court decides to summon 1,800 jurors. Let's assume that this court decides to seat a jury of 12 with 6 alternates, given that it's going to be a very long trial. If this court were to summons a jury of 1,800 jurors, which was the amount that was summoned in Ada County in Daybell, this court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works. This court.
That's exactly right. That it's the same number of potential jurors, regardless of what county you summons them from. That's obvious. Obvious.
It just as easily summons in 1,800 jurors in either location. And if this court were to summons 1,800 jurors, only 1 in 100 would have to qualify to sit on a jury in order for this court to proceed to trial. So if you look at that 1,800 number and you look at some of the survey numbers, let's look at total prejudgment. Right,
I'm going to skip some of this. There's a point right at the end that makes a good point about the practicalities of it. Okay. That all the defense has taken into account is potential bias, which is fine. They haven't convinced me that changing the venue is going to reduce the amount of bias based on the figures that they themselves have presented, or based on the psychology that the psychologist presented. It doesn't give me any confidence that he's going to get a fairer trial in Ada County. But they've completely ignored any practicalities, whereas the state made some very, very important points in relation to the practicalities of moving it to Ada County.
The court's employees to have a place to go for courts.
Go back. Where are we at here? 46. Let's go to 40. 44. Right, so this is about the practicalities of moving the trial to Ada County.
Folks in Latah County visited or walked by the home where the murders occurred. 60%, nearly 60% didn't. That means that out of a jury pool of 1,800, over 1,000 people would not have gone by the home where the murders occurred. Are you or a family member, a student or employee at the University of Idaho in Moscow? 75% of folks in Latah County said no. Moving to the convenience issue, I think it's important to note that Latah County is not a tiny little community. Latah County might be close-knit, but it is not a tiny little community. Latah County is one of the top 25% of most populated counties in the state of Idaho. It's 11th out of 44 counties in Idaho. There are 32,000, according to Dr. Edelman, jury-eligible citizens in Latah County. It is not so tiny that we could not summons in a jury of 1,800, a jury pool of 1,800 folks. Since the convenience argument focuses primarily on Ada County, that's what I'm going to address today. So starting with the size of courthouse and the ability to house parties and court staff, it's already built into the Latah County Courthouse for the court to have a place to go, for the court's employees to have a place to go, for court staff, for the court staff attorney. All of that is built into the Latah County Courthouse. Unlike moving to Ada County, where the courthouse would have to accommodate the court and all the court staff. Similarly, the prosecutor's office and their staff already built into the Latah County Courthouse. No separate accommodations would be needed. The defense will have to have accommodations wherever they go, and certainly they are entitled to privacy and accommodations that will allow them to prepare for this extensive trial. They absolutely should have that. But they are going to have to find those accommodations regardless of where this trial is located, unless it does get moved to Kootenai County. And so keeping this trial in Latah County would be a lesser burden on the Latah County Courthouse, in the sense that they would simply have to find accommodations for the defense team rather than finding accommodations for everyone. As to juror space and security, as well as the argument of overall security, it is true that the Ada County Courthouse has a precedent of handling large trials. And it is true that Ada County does a very good job with that. But the reason Ada County does a very good job with handling these high-profile cases with security, with court staff, with organization, with getting jurors in and out in an organized fashion, the reason Ada County does a good job with that isn't because Ada County has a physically bigger courthouse. It's because Ada County has diligent, competent, and professional staff. And I have every reason to believe that with the 9 months we have until trial, that this court staff here and security could also have the time to prepare and make operation plans and all of the things that go into having a trial of this magnitude. I have no doubt that they can accomplish that with careful planning and preparation over the many months between now and trial. It is also my understanding that there is a means to bring jurors securely into this courthouse outside of the public view. Moving on to the cost of travel expenses, counsel referenced the cost of transportation to and from the airport and correctly noted that the Spokane Airport is considerably further from the Latah County Courthouse than the Boise Airport is from the Ada County Courthouse. That's absolutely correct. However, the Lewiston Airport is a shorter drive, again, about 30 minutes, and does connect to some major airport hubs. That would be another option. But even taking into account that there may be some additional rental car expense for the few out-of-state witnesses that we're going to have, that would be negated and then some by transporting all of the local witnesses from Latah County down 300 miles to Boise, by paying for accommodations in Boise for the court and court staff, the prosecutor's office and prosecutor's office staff, and the many local witnesses that will be testifying in this trial. There's also the logistical issue of transporting evidence for a 3-month trial, the chain of custody issues, the evidence tech from the Moscow Police Department, and it's my understanding there's only one, taking him out of his role up in Moscow here for 3 months and having him in Boise, trying to manage this evidence in a location that we would also have to arrange for, and dealing with the chain of custody issues, transporting the evidence back and forth.
All right, I'm gonna leave it there. However, those things were like that hit me like a ton of bricks. And this is right at the end of the hearing. And I thought, yeah, and things that I just hadn't thought of, like the logistics of getting all the evidence 300 miles and taking people out of their lives for 3 months and having to accommodate them all for 3 months. It's not a short trial. It's not doing it for a week or 2 weeks. This is 3 months. So look, if I'd been convinced by the defense's argument, I would have said, look, this is going to be expensive. This is going to be time consuming. This is going to be difficult, but we have to do this. Or they have to do this. Latah County have to do this to ensure that Bryan Kohberger gets a fair trial. So the expenses and the logistics argument isn't the deciding point for me. It isn't the bazinga point for me. But the fact that the defense hasn't been able to convince me that changing the venue is going to make Bryan Kohberger's trial fairer, I have to then refer to that logistics and that expense to say, if he's not going to get a fairer trial in Ada County, why put Latah County through that expense and those logistics? It doesn't make sense. Anyway, it's not my decision and it's not your decision. It's Judge John Judge's decision. And he said in his summing up that this is the most difficult professional decision that he's ever made. And this is an experienced judge. Now, maybe that's hyperbolic, but I think he's honest when he says that this is probably the most high profile case that he's ever going to sit on, he's ever sat on. It's a considerable responsibility. And he knows that this defense team is on it. And he knows that if he chooses not to move the venue, that's a possible appellant issue if he gets convicted. But I don't think that should be the deciding factor either. The fact that he's got a good defense team who are litigious, who are dedicated to Bryan Kohberger's cause, that's not the deciding factor either. So even though I'm open-minded and I've no horse in the race, I don't care where they have the trial. Bryan Kohberger isn't special. And all the arguments that have been made about jury bias are evident in any other case. So Judge John Judge really does have a difficult decision to make, and I'm going to let him make it. And I'll be happy with whatever decision he makes, because it's not a fair system. It's not a fair system for any defendant. They're on the back foot, and that's that. All right, guys, I've been on here longer than I anticipated. I've been on here for 2.5 hours. Cassie's telling me that she needs a wee, and I've got to go. She normally gives me only 2 hours, but she obviously realised I haven't finished, and she's given me 2.5 hours, and she's bugging me now. So I am going to go. Thank you so much for joining me. I know this is not everybody's cup of tea. This is not interesting to everybody. The numbers in this live stream have been quite low throughout. I don't care, because I think this is a very important perspective. I think understanding the psychology of this topic, I think, is worth putting out there. I haven't seen anybody else discuss this from a professional psychological perspective. I've seen lots of law tubers who get thousands and thousands of people in their live streams, and fair dues, people want to hear from the law tubers. But don't forget that, when any party is putting together an argument based on psychology, then we've got to discuss that psychology. And we've got to look at the realistic nature of that psychological research. So even though it's not everybody's cup of tea, I hope that more people will watch this on the replay and at least give some consideration to the things that I've said. So anyway, I'm going to go. Thank you, as always, mods. Thank you for joining me here on this Sunday afternoon. It's raining heavily here, and it's not thundered again, but I think we are in for a thunderstorm. So I like thunder, so that's good. And yeah, thank you for those that donated at the beginning of the live stream. Welcome to the new members, and I will see you next time. Bye, guys.